Good afternoon to everybody. I am Matteo Nicolini. I am Associate Professor of Comparative Law at the University of Verona in Italy. And I thank the board of the Rivista di Diritti Comparati because they asked me to introduce and to deliver a short presentation of my last book on legal geography and the production of space. I am a comparative lawyer with a background in law, but keenly interested in doing or trying to do cross-disciplinary research. And the idea of examining the relation between law in general and comparative law in particular and space has always been part of my research interest. The book I wrote is one of those attempts to reappraise the role of comparative law when it comes to considering cross-disciplinary research. It is, I can add, a kind of a part of a broader existential journey about the meaning, the role, and the function of our discipline. We know that this topic, where comparative law should be located within the legal disciplines, has always been part of our research. It's also part of the way comparative law has been conceived of and studied for a long time. What I can say, it is interested in understand both the theoretical relation between the law and geography, as well as their empirical implications. So the methodological choice adopted veers towards the idea that comparative law rubs shoulders with other science, paraphrasing Jaakko Uusa's latest book. The idea is that of interdisciplinarity. I assume that comparative law has a great relation with interdisciplinarity, and that this disciplinarity implication, cross-disciplinarity implication, are also part of the discipline. It has to run counter the autonomy and the closure of doctrinal law and understanding what the law means in context, and therefore to gain a deeper appreciation of the meaning of the law. So the book also has methodological ambition, trying to abandon the narrow viewpoint of legal doctrine and to understand how the law may have a proactive role when it comes to the world, to the earth, and to geography. The idea is that we can use comparative law as a kind of instrument, a device that helps us to remain vigilant and keep the door of the law open to a constant conversation with the world out there. But not only a conversation, I may add, also a way of producing the word, because the book is also on the relation between comparative law and the production of space. We know that the law has always been in a constant relationship with geography. Suffice here to remember how the relation between law and geography has also been considered in terms of the theory of state, how the law and geography interact when it comes to consider borders, as well as the bordering processes, the idea of occupation, discovery, both in international law and in state law. It also took several forms and served a variety of functions within the idea of international law and state law. We can consider, for instance, the idea of territory. Territory is a concept that is part of the political theory, and is a tract of geography, is a tract of land legally meaningful. Also, the idea of place names policies, federalism, outer space, and the seas. Well, these are geographical areas, locations, hyper-regulated, or we can say also hyper-regulated spaces. But the role of geography and its interaction with the law has also been part of constitutional law, the idea of demarcation and territorial reshuffling, as well as the idea of secession. And we can also find hints of law and geography also in the most advanced way of doing geography, the GIS and digital geography. We know that when we use the mashups or the GIS, and we go online, sharing our imaging and lived geographies, we do it not free, not gratis, but free. There are several implications in the interchange of data between us and the provider, as well as in terms of privacy. And then we also have the idea of unbounded spaces like the atmosphere, transnational law, global law, and also the spaces of the Anthropocene and of the climate change. Well, there we can find that all these relationships between law and space has been under-theorized. Well, there is a group of critical legal geographers that had attempted to do it, but in strictly legal terms, the role of the law within geography and the role of geography in legal studies has been under-theorized. So the idea also of considering the law an artifact and a product that is able to be processed or to reprocess spaces, well, this idea can be unpalatable even for those legal scholars actively involved, as I am, in cross-disciplinary research. So, but comparative law helps us to understand that space produced in terms of cultural geography is also produced through legal practices. And the idea of the book is to reframe this background, these manifold forms of legal and geographical interrelation in terms of legal geography, to say, trying to contribute to creating and therefore establishing this intriguing area of law where several other legal geographers like Nicholas Blomy, Aaron Braverman, or Sandy Keder and David Delaney have already contributed. So the idea is to bring back space and law together in the real world, avoiding the activity of bracketing, that is to say, the closure, the fixture of the law that is closed within its own precinct and unable to understand the world. The world needs the law, needs regulation, but the law needs the world in order to gain knowledge and understanding. So the idea of blending those in examining the variety of space or the way of space production is intriguing. So the idea is to find the perspective whereby the relationship between both law and geography might be reappraised and rearranged. And I detected three ways of spatial production that might be suitable to our investigation. The first one is the law of spatiality. And so the book provides the readers with an insight of the methodological reappraisal of the relation between law and geography and legal geography, in order to understand how space is produced also through legal practices. And law and spatiality is a case in point, because it's the way physical, geographical features acquire meaning and significance, that is to say, they are rewritten through the law. The idea is that the law is able to convey a powerful ideological meaning, not changing the existence, not affecting the existence of things and out there, islands, seas, mountains, rivers, plateaus, they are there. But the way the law is able to convey a new meaning is not a problem, a matter of existence, but of meaning. It is not a problem of ontology, but of how the ontology is perceived, reframed, and rewritten by actors using the law. So the idea is to create, to reshuffle the word in order to assign it a meaning. It is a clear artificial mechanism of rewriting, redrawing, and reassigning a new meaning to the word. But it is so common that the meaning assigned to a watershed that becomes a border, to a river that becomes a place that is divided between two communities, islands that are considered dots there, or the open seas that are deprived of every form of sovereignty, where these ideas, this meaning assigned to these natural, physical, geographical spaces, it proves to be a kind of neutral reality. When we are able to assign and to normalize the meaning we assign to a geographical feature, where they become common sense, and environment and nature cease to be an artificial mechanism and becomes something that is kind of neutral reality. The second way we can readdress spatial production is in terms of the spatiality of law. It is the joint application of human and physical features in order to reprocess territories, communities, and explain the variability of legal system. The idea is that the law can reprocess community and geographical attributes and features in order to assign them a clear legal meaning and display the law on a kind of a map. So the idea is the spatiality of law explains how we humans create the legal systems of the world, and we are able to make them absorb the meaning we want, and therefore to assign a kind of ranking to them. The last form of spatial production I address in the book is then that of counter-legal geography. These spaces are places where there is a dialectic between contrasting legally, spatially meaning. The idea is globalization, when you have an ideological space of consumerism and smooth circulation of capital, services, and goods, vis-à-vis the spaces of communities that can run counter this idea of consumerism, the spaces of terror and counter-terrorism. We have a dialectic between different visions of the same word, or the so-called opposition or between resistance and gentrification in urban planning and in communities that are characterized by informal settlements that turn to be gentrified places in the aftermath of the intervention of the order of global capital. When we have these three way of processing space, the law spatiality, spatiality on law, and counter-legal geographies, are then applied in the third part of the book to the creation of meaningful territorial spaces in the case of federal legal geography, and to unbind these spaces, globalization, climate change, transnational law, and the atmosphere, in order to explain how these spaces are produced according to the three perspectives I have already explained. Well, the idea is that each process of spatial production, whether it may be of law and speciality on law, or counter-legal geography, even both in territorial or in unbounded, territorialized space, well, they all have something in common, a kind of matrix there. The idea that humans have always tried to grasping the meaning of the word practically and intellectually. So the idea, my intervention, my presentation, my book launch is try to aim to make geography and law more cross-disciplinary, also in the term to create a kind of more the idea is to make the word clearer in terms of legal geography. So the idea is to present you, to invite readers to and you to read a book that is a real cross-disciplinary journey through law and geography, and where we can find a kind of synopsis of how space is produced. And at the very end is, what is legal geography? In my opinion, I'm reading for the book, it is a way of grasping the world intellectually and scientifically. On its own, it is a new ambit of scientific research. It is not a matter of being itinerant participants or self-declared legal geographical scholars. I think that we can all become legal geographers by way of acquaintance with the discipline of law and geography, and also via comparative legal toolkits, which, as I told you, are open to cross-disciplinary. The idea, so, is to reassess the world's knowledge, not picking up the arguments we need in order to create the law as something that is unfettered from the Lord, but the ability of understanding the world in order of grasping it and to make it meaningful even for our communities. Thanks.